Date of arrest.
Mr. Parker, no, he's got that.
Oh.
All right, ma'am, is it Isis?
Yes, ma'am.
Traddles? And Ms. Traddles was previously in court and entered a plea of guilty to the state jail felony offense of injury to a child in cause number 25 DCCR 1478. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Have your honor. State has, Judge.
Are there any additions or corrections?
Nothing, Mr. Spencer. Judge, I would like to address the statement made by the victim's mother, Heather Powell, on page 1 of the PSI, where she claims that the district attorney's office has not returned her phone calls or emails. For the record, I have not received any phone messages, or emails from Ms. Powell. I did, however, my file reflects that I did send my standard, what I refer to as victim letter, to Ms. Powell, asking her to contact me about the case back on October the 16th of 2025.
Thank you, Mr. Coleman. Any other issues with regard to the pre-sentence report?
No, Your Honor.
Any reason not to go forward with sentencing at this time?
No, Your Honor.
All right, ma'am, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, at this time, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And including the regular rules and conditions, part of yours are going to be that you are required to be on the mental health caseload and to participate in mental talk services. That's meant to help you be successful on probation and everything else. So obviously it's something you should be doing, but now it's something that's court ordered. So you've got to make sure and do everything that they ask you to do, as well as all of the other conditions. You're also not allowed to have any unsupervised contact with any child under the age of 18, and have no contact at all with the victim or the victim's mother, Ms. Powell, in this case. So that means no contact, obviously in person, but it also means any other way through social media or phone calls or emails or text messages or anything like that. You understand? If you do everything you're supposed to on this probation, then this is an excellent opportunity because you will not have a felony conviction on your record. And at the end of the probation, the case will actually be dismissed if you're successful. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
Also, there will be ordered $472.26 in restitution as part of this case, and you're not allowed to work anywhere in child care or daycare facilities, even private. Okay, so you can't do private babysitting or anything like that. Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am.
The hearing opens with Traddles confirming her identity and prior guilty plea to injury to a child. The court reviews the pre-sentence report, addresses a claim from the victim's mother about lack of contact from the DA's office, and moves forward. The judge defers proceedings for 5 years under strict probation, mental health supervision, no contact with minors or the victim, restitution, and employment restrictions. The warning is clear. One violation could mean state jail time.
Thanks, Judge.
Okay. Thank you. Ms. Paul, I received a note that you refused to take a drug test.
Yes, ma'am, because I leaned against the thing. I just finished sneezing back there, and I felt like I was being singled out. I know I have alcohol in my system
So
from
here's
the night before.
So let me explain. If you don't test and let me see what is or is not in your system, then I'm going to assume that you're positive,
Okay.
and I will raise your bond for sure, and you'll go to jail.
Okay.
So do you want to take the test and let me see what's in your
I
system?
don't have anything in my system besides alcohol.
Then go take the test.
I can't pee.
We're going to give you some water.
I just had water.
Then you want me to go ahead and send you to jail?
I don't know. You haven't even finished running down my charges to me.
What?
Running down my charges to me.
What do you mean?
What I was here for, or if I'm gonna get a lawyer, and all that.
First things first is I'm ordering you to take a drug test. If you refuse the drug test, then you're refusing a court order, and I'll raise your bond and you'll go to jail. Then you'll have an attorney come visit you in jail and they'll go over all of the charges. If you want to take
So
your
I can
time,
bond out,
yeah, your bond's gonna be raised though.
but could I bond out today? That's what I'm asking, because I
You
have,
don't know what I'm gonna set your bond at
because I'm
yet.
trying to go to
You're-
work.
Well, then you should probably take the drug test.
Let's try.
Because the more you refuse to do it, the more concern I have, and probably the higher your bond's gonna be.
I'm just worried about getting back to my kids and going back to work because
Then take the drug test. So either there's something in your system other
I
than
have
alcohol.
something in my system. I
Right.
said that.
You said you have alcohol.
Yes, ma'am.
I'm not worried about that right now.
Maybe some weed.
Take the test. Let me see what's in your
It's
system.
weed.
Okay. I want to see what's in it. Take the test. And then we'll decide. Just because you test positive does not necessarily mean that I'm going to raise your bond, but we're going to have some discussions depending on what's in your system. So if you want any opportunity today to walk out that door instead of that door, go take the test. Otherwise, I'm raising your bond right now.
I'll consider and see if I can be.
Go try. Justin Wallace with Mr. Lewis.
The focus shifts sharply as Miss Paul is confronted about refusing a drug test. She admits to alcohol and possible marijuana use, but hesitates to comply. The judge makes it unmistakable. Refusal equals a bond increase and jail. The tension escalates as Paul weighs work, her children, and immediate custody. The court frames the choice plainly: take the test and possibly walk out, or refuse and be remanded.
Okay, so you've refused again.
I didn't refuse. I told them that I couldn't go. I
Well-
didn't refuse for the sake.
There's no way that after a couple hours you can't go a little bit. So I'm gonna find Miss Paul, based on your, number one, that you told me that you smoke marijuana. You told the man in the back, the drug tester, that you smoke daily, and that you used alcohol also yesterday, which alcohol's, I'm not
Yes, ma'am.
so worried about unless you're driving, but obviously using marijuana is a violation of the law, which means it's a violation of your bond conditions.
Okay.
And so let me see something real quick. Your current bond that you. I need to take a look at probable cause affidavit. Give me just a minute to get more information about you and your case, and then I'll decide what to set your new bond at.
Miss West. Can I say, I know that I'm going to jail today, that's
Mhm.
fine. But I feel like I've been the victim in this and I have the proof. I'm just overwhelmed at this point with the whole situation.
Well,
Because the girl is still harassing me.
have you called the cops?
No, but I have the proof of her going to my job recently. Letters from my job and her job.
All right, just hold on. You're gonna need to tell all that to a lawyer. That's. You still have that assault down the hall pending?
I have to go to that courtroom for the same person.
All right, so based on the limited information that I have.
Procedure. Jeez.
I'm going to again find that you violated the conditions of your bond and in cause number 25 DCCR 1752, raise that bond to $35,000. A condition of that bond, if you make it, is that you have to have a drug patch put on within 24 hours of your release from custody.
Okay,
And obviously, if you get out soon, I'm going to assume that that drug patch will initially be positive,
okay,
but it should be going down. So it
okay,
doesn't just test whether you're positive or negative. It gives me an amount.
okay.
And if it's not going down, then that bond's going to go up even higher. Do you
Okay.
understand?
Yes, ma'am.
If you don't get the drug patch changed every 2 weeks like you're supposed to, some people say, oh, it fell off. And they don't just fall off. Okay. So you need to make sure you have it on at all times, get it tested when you're supposed to. If you
Okay.
make that bond, go back with the bailiff.
After continued resistance, the judge cites Paul's own admissions of daily marijuana use as a bond violation. Despite her claims of being harassed and overwhelmed, the court moves decisively. Her bond is raised to $35,000 with strict conditions, including a drug patch monitored for declining levels. The message is firm. Compliance is measurable, and any increase in substance levels will trigger even harsher consequences.